You can hit. You can hit.
Go live, sir. That's okay.
Yeah. Yes, we are live.
Okay.
Hello, everyone. Good evening. Welcome to the show on SIPP.
Good evening, sir. Good evening,
So,
Vijay Bhaskar Reddy garu. Thank you so much for joining in live, sir. Today we have one listener who just joined in less than 1 minute, Suneet Mantri garu
yes,
from
yes,
Epidemiology. Thank you, Suneet garu, for joining in live. So, good evening, Srinivas, sir. Welcome to another episode of Scheme for Facilitating Startups, Intellectual Property Program. So, mainly SIPP program, as Vijay Bhaskar Reddy sir said. So
yes.
over to you, Srinivas sir. Probably would you like to? We need to know a little about Vijay Bhaskar Reddy garu before we jump into the questions. As an IPR attorney, a trademark, a copyright, patent agent. So, would you like to share your journey to our listeners, Vijay Bhaskar Reddy garu?
Yes, Raj Garu. Yeah. So, welcome and thanks for giving me an opportunity to speak on this occasion and coming quickly to this session like SIPP, Startups Intellectual Property Program. So, this, as you know, this was started in, I think, around 2016. I was one of the first members to get enrolled under this scheme, under the Startup SIPP program.
Wow.
So this is a very good program for startups because many times startups, like if you want to go to any law firm or if you want to get any correct and accurate information regarding the filing of IPR in India. So this the facilitators who are registered or who are enrolled under SIPP scheme are the best people to get correct information. So I got registered in 2016. From
Okay.
then onwards, I have been filing several patents, trademarks under this scheme.
Okay.
Yeah, I'm. My name is Mr. A. Vijay Bhaskar Reddy. You can call me Mr. Vijay. I have done my BTech from Osmania University in dairy technology, and thereafter I did my master's program. Thereafter, I worked as a patent analyst in a firm,
Okay, sir.
and then I became a patent agent. After becoming patent agent, I got enrolled in this scheme,
Okay.
and prior to enrolling itself, I was a trademark agent as well. So I got enrolled under patents as well as under trademarks.
Okay.
Thereafter, I did my LLB, and now I am an advocate enrolled before Bar Council of Telangana and member of High Court Telangana Advocates Association.
Wow.
Yeah.
So
So,
it's an
okay.
exciting journey. So when did you both, I mean, Roots IP and Eevatech, Srinivas sir, when did you both meet? Like, were you college mates or?
No. It was through one of our other colleague, Mr. Naveen Kumar Anumala. So
Okay.
we three of them started Roots IP Services LLP mainly with an intention to provide patent search services mainly for applicants in India and abroad as well. So it was, I think, in 2017 we got incorporated Roots IP Services.
Okay.
Yes, and thereafter we worked for some time, and still we work together on a case-to-case basis. And Srinivas comes to me, and I go to Srinivas on various aspects. So this is how we knowledge sharing is very very important in
Yes,
any
sir.
area, especially in IP, because in you have to get updated regarding the forms, fees, and regarding the procedures that are happening, maybe relating to examination reports or relating to the hearings. So unlike trademarks, so patent has completely different because many people think that it is very easy to get both. It is easy to get a trademark, but not it is easy to get a patent application granted. You
Yeah.
can file a patent application. You can file a patent application. You can get it published easily, but then in order to get a grant, yes. So there are so many criteria which need to be fulfilled.
Okay.
So in terms of formalities as well as in terms of technical.
Okay.
So formalities related to whether the fee is paid properly, whether all the forms are submitted properly, whether the signature is done by the respective people on the respective forms or not,
Okay.
whether the uh, page numbers, the line numbers are properly submitted or not. So
Okay.
all these come under formalities. And the other important thing is the technical things.
Okay.
Technical things means, so in order to get a patent granted
Yes, sir.
for an invention,
Mm-hmm.
so there are three criteria. One is the novelty, and the second one is the non-obviousness, and the third one is industrial applicability.
Okay. Which is
So first, let's come to the novelty part.
yeah, sir. Before we jump into the details of novelty patent, I would like to thank all the listeners, Lakshmi Garu for joining in, Lakshmi Sailja and Deepa Esturi, another patent attorney all the way from Bangalore for joining in live. Thank you so much. She's from Origin IP Solutions, Chandrasekhar
Yeah.
Garu and Giri Satish Sunitji. So just give me a thumbs up if you are listening to us, and if you'd like to join the conversation on the speakers panel, Deepa ma'am or Sunitji, feel free to just raise your hand, use the react button so that you can join the speakers panel. Yes, Vijay Bhaskar sir. Let's jump
Yes.
into the novelty patent.
Yes. So in order to get a patent granted, so apart from the formalities that we discussed a few minutes that just now, so we need to focus on the invention part. So the
Okay.
technical part. So first thing is novelty. Novelty means it should be new. So what does it mean new? So that means the invention should not have existed prior to the filing date.
Yes, sir.
Prior to the filing date. If 4th of March is the filing date, so that means it should not have existed till now,
That is
till 3rd, yeah, or till 4th. So that means till the time of filing, it should not have existed. That means you should be the first one to create the invention. It could be in the form of a product, it could be in the form of a process, it could be a device, it could be a sub-assembly, the patentable subject matter. It could be any form of the patentable subject matter. So here we need to see how can I know whether it is novel or not. It is the duty of the applicant. It is the duty of the applicant to see that the invention is novel. How can the applicant do? He can search on his own whether the invention is already there in the form of a patent, in the form of a publication, in the form of a product, in the
okay.
form of a brochure, in the form of a existing knowledge in the society. So in
Okay.
various forms. It is the duty of the applicant to see, and once he ascertains that yes, this invention is novel, then yes, the novelty criteria is fulfilled from his part. From his part.
Okay.
Yeah. Yeah. So as an applicant, we need to do something. And there is also other thing is we can also go for a professional patent search. Professional patent search. So the patent search will be conducted in a paid database using certain keywords, using the IPC classes, using various other strategies. It's not so easy, but there are various strategies to ascertain whether the invention is novel or not.
Okay. So basically,
So
with respect to the applicant who need to do manual search, or he can take a professional help.
it depends upon the funding. If funding is not a problem, let's say the professional search will cost somewhere around 10,000 to 25, 30,000. So a
Oh.
minimum of 10,000 will be there. So here what the person does is he understands that invention, and he puts down the features of the invention. I call features.
Okay.
What is the uniqueness of that one? We list it down. Okay, feature 1, feature 2, feature 3, feature 4, feature 5,
Okay.
something like that. At least some one feature should be unique.
Yes, sir.
Then what we'll do? We'll conduct a search.
Okay.
We'll conduct a search, and we'll see whether the feature 1 is already existing or not existing. Similarly, feature 2, feature 3, feature 4, feature 5. At the end, the IPR attorney or the patent searcher, so he will prepare a report called as a novelty report or patentability report.
Okay.
So there he will give clear indication. Yes, if it is there, then he need to show the proof where, in which document,
Okay.
in which patent document, in which publication, in which research disclosure, wherever it is. It could be on Google, whatever the source. But we have to clearly indicate, yes, so and so document has disclosed feature 1, and we'll also indicate the exact terminology of that one.
Okay.
Otherwise, it will be the interpretation of a sentence could be different for different people.
Okay. So this
So
takes
here,
this entire process takes couple of weeks or a couple of months or years, sir?
no. It could, generally we will try to complete it within 1 week. One
Okay,
week.
in less than a week.
Yeah. Yes. So because there are certain things where we shortlist.
Okay. So what
So
are
for
the,
example,
I'm sorry to interrupt you, sir. Please go ahead. I'm sorry.
yeah, yeah. So here we'll use various strategies, because otherwise what happens is like we'll get so much of junk. Even if you put any keyword, whether it is a chair, pen, table, so the relevant will be only some 15 to 20%. 80% of them will be junk. Somehow it gets included because of keyword, and even though you use classification as well, so it is not an easy task to shortlist.
Okay.
So as a pattern searches, what I do is, okay, let me shortlist, for example, 20, 30, 50 patents, and then we'll have a discussion with the inventor again, once again, to understand the features properly. Based upon that one, we'll try to say, okay, so looking at these patents and looking at these non-patent literature, looking at these other websites, so this is the information collected, and based upon that one, we'll try to say, okay. So at the end, we'll say that whether novelty is like a yes or no type question.
Okay.
Always, this is a very, very important one. Yes or no. So whether it is novel or not novel. It
Okay.
could be not like something like this, maybe it could be novel. No. Many times it's very clear. Novelty is like yes or no.
Okay.
Whether this device is already there, yes or no.
Okay.
Whether this process is there, yes or no.
Okay.
So it is a very, very difficult thing, because whatever we have collected so much of information in the patent search, so many patent documents are very, very close, very, very
Okay.
close.
So let me do a quick poll, sir, Vijay Bhaskar Reddy garu, with whatever the process
So,
which you shared. As you are like Sachin or Dhoni in this field, you know how to. I mean, as you are more passionate about it, it's very
yes,
easy for you. But let me take a quick poll from the audience, as we have 8 listeners.
yes,
I'd like to thank Chandrasekhar also, Giri Manu, and Chandrasekhar Sayani, Deepa Esturi, and Sunit. So, if any of the listeners, I'm glad that Humera also joined. She's from Kurnool, Andhra, all the way from. So, if you'd like to join the speakers panel regarding the patents or IPR, or if you'd like to ask any of the guests any questions, feel free to raise your hand so that you can join the speakers panel. And quick question, sir. So, what are all the forms required to be filled for filing a patent application in India? Do they need to fill like too many forms, or is it only a single?
for patents, yes, there are around 5 to 6 forms that have to be filled,
Okay.
and for trademarks is only the authorization form that has to be given by the applicant. So trademark, I said in the initial itself, it is relatively simple,
Okay.
filing of a trademark or filing of in even a design application.
Okay.
But what we are talking is about utility patent application. So
Okay.
patent application do not be confused with the design patent and the utility patent.
Okay.
So
So,
utility patent is mainly for the invention, or it is a solution for a problem.
okay.
Whereas design patent is for the shape and aesthetic appeal.
Okay. So, this form one
So
and form two, uh,
yes,
is there?
Form 2 is a one Form 2. So we can file a patent application in two ways. One as a provisional patent application,
Okay.
or the complete specification. In
Okay.
case you need to choose to file as a provisional patent application, so then you have to mandatorily submit complete specification within a period of 1 year.
Okay.
So what happens if I do not submit? So the patent application is deemed to be abandoned. Deemed to be abandoned. No need. No one will say it is abandoned. Automatically, it is abandoned.
Okay.
So here, yeah, this is about Form 2. So
Okay.
Form 2 contains the technical details of the invention.
Okay.
So it contains technical field, it contains background, it contains summary, it contains a brief description of drawings, it contains detailed description, it contains claims, it contains abstract, it contains figures or the drawings document. So
Yes,
these
sir.
are the
And Srinivas,
different
sir.
sections.
Okay. Yeah. Thank you so much, sir. What, in case if the child is filing a patent application, is there a different form, or is form one and form two enough? Like,
Yes, and yeah, here if one of the inventors or one of the applicants is a minor, let's say, so
okay.
then there should be undertaking from the guardian as well, parent, guardian, whoever it is, one adult.
Okay.
Like similarly, if you want to register the property in case of minors, so what you will do? So generally, there should be like one adult who
Okay.
is the guardian or the caretaker for this
He,
person, because
so,
the law allows only to file for the majors,
okay.
to
Is
find
the
any
Form
property.
26 the same, sir? The Form 26, is it the same?
Form 26 is for authorization, for agent. So
Oh,
here the patent application can be filed by themselves, like the applicant himself, he himself or herself can file it. The applicant can be any individual, the applicant can be an entity, the applicant can be a startup entity, the applicant can be a private limited, the applicant can be LLP, the
o-
applicants, sometimes even the applicants, like one or two applicants or three, they can come together and they can file a joint patent
okay.
application.
So as we jump into the detailed set of forms, sir, it's like Form 18, 18A, which we will also talk, but I'd like to thank Sunit ji
Yeah,
who joined the,
let's go with the first form one. Form one contains the details of the inventors, details of the applicants. So here, inventor is the person who invents or who creates the invention. The
okay,
applicant is the person who files the invention. Sometimes both need not be the same. The inventor is a human being. The
okay,
applicant need not be a human being. The applicant can be a human being or a legal entity, like a
okay,
company, like a
okay,
company. So if you have taken a startup, for example, the startup becomes the applicant, not the inventor. The inventor is the person.
the CEO
The
or the
inventor is the
founder,
person,
yeah, probably a
a
person.
founder or their engineering teams or
Okay,
their researchers who has who has conceived that idea.
okay.
So
So,
that person or group of persons will become inventors.
okay,
And this startup entity, DIPP entity, becomes applicant.
okay,
So Form 1 will have the details of inventors, their nationality, their address, their email ID, phone number. Similarly, the details of the applicants as well.
okay,
And the title and the number of pages, because the patent document, if you look at, so the fee whatever we are paying, rupees 1600 for natural persons and the startups and the MSMEs, this is valid for up to 30 pages and up to 10 claims.
10 claims, okay,
So in the, yeah, in the form one, we need to clearly inform the patent office how many pages are there in terms of description, in terms of claims, in terms of figures, everything,
okay,
everything. We need to inform them in a proper way, and the number of claims as well. If
okay,
the number of claims are more than 10, we need to pay the additional fee to the patent office. So
okay,
how much? So if you take, if the number of pages exceed 30, so the fee is 160 rupees additional
okay,
in addition to the standard fee of 1600.
okay,
If there is one additional claim in excess of 10, then the additional fee is rupees 320. So that
okay,
means if there are 11 claims, so the fee will be 1600 plus 320. For
okay.
example, if the patent application instead of 30 pages is going to 31 pages, so then the government fee will be 1600 plus 160.
Okay. So let's
So,
let's before we jump into further, sir, let's hear it from Sunit ji, Sunit Mantri ji. Thank you so much, sir, for joining us live.
Yeah, hi.
Um,
Yeah, my question is to Srinivas or the Vijay Bhaskar can answer the question.
yes, sir.
So, I just want to put it in the practical terms. If any inventor approaches you, in that time he'll be having an idea in his mind. He doesn't write any claims in the document or doesn't write anything on paper. He comes with an
yes,
idea.
yes.
So, in that situation, how do you make the inventor understand? You're talking about the features and all those things. You'll check in the backhand with the available softwares or databases.
Yes.
How do you check the
Novelty part.
novelty
Yes,
of that
yes, sir.
particular idea? So, in first instance, or
So
you
first,
take,
what generally normally we do is we have first thing is most of the times we create an NDA. So if the new inventor, because he has to be very, will be very cautious to disclose his idea, because he thinks that anyone can copy, right? Anyone
yeah,
can copy his
correct.
idea. So first thing is the non-disclosure agreement, we make it with the
Okay,
inventor or the applicant. So once that non-disclosure agreement is there, it is bound. So the IPR attorneys are bound to keep the invention as a secret. We will not disclose. Daily we'll be interacting with so many inventors, applicants, but we'll be keeping that as a secret
Okay.
by having NDA. Next thing is we'll be providing an invention disclosure form to fill certain details. Okay, like names of the inventors, names of the applicants, and a description part about that one. And we'll also most of the times we'll ask the inventor what is the new thing about this invention, because if you talk about a computer, computers are already known. So what is new in that one? If you talk about a pen, pens are already known. What is that new thing, or the new component, a new system, new thing? So once we will ask so many questions to the inventors to get the right answers to proceed for the filing.
Okay.
So to get the right answers for the what are the features, because many times the researchers, so they will be explaining in 2 pages, 3 pages. Even if we ask, some people give some 10 to 12 page, but it's many times it will be difficult. What is the crux of the invention in about 3 to 4 lines, in about 3 to 4 points? So
Yeah,
after
but
discussing,
sir, sorry to
yes, no,
interrupt
tell
you,
me.
but you will also means ask some information from the inventor, but the inventor doesn't have any knowledge or he doesn't go into the prior art in that point
No,
of
no,
time.
forget about the pair. But he knows, right, what he has invented.
Yeah, so
So
from
we'll
there
take
on you
that.
can move
Yeah,
forward.
yes. We'll take that. Okay, what you have invented, sir, as far as you know, because no one knows whether it is already existing or not.
Yeah,
From your perspective, what you have invented. Okay, you know the even at least a little bit of the prior art. Maybe if you take any mouse, maybe it could be a wired mouse that you are knowing, and you are the first one to create a wireless mouse. So you know, say that till now you say that okay, sir, till now wired mouse is there. I am the first one to create a wireless mouse. Okay, wireless mouse. So we'll say that okay, you have the inventor for this wireless mouse. Okay, sir, now you tell me how this wireless mouse works. What are the different components in it? How these different components interact to make it the wireless function as if it is a wired, right? Same functionality should be there. So okay, now you'll explaining, okay, I have this transmitter, receiver, this is so and so, everything. So we'll ask so many questions. Okay. Then okay, after maybe after 30 minutes or 1 hour, we'll see that okay, reasonable information is uh, provided by the inventor, and then we'll put it in the form of a document, and from that we try to extract the features. Okay, this is one feature three. So the information that you may not be knowing as a features, we will be converting that information into features of the invention. So we'll be asking questions. So main thing is we'll be asking questions to the inventors so that he answers, and we'll convert that entire thing into a proper invention.
Okay. So if the inventor is not sure about if somebody else across the world had
No,
invented.
no, we are not talking about the novelty part here.
Okay.
We are only talking what he has invented.
Yeah. Sunitji, please go ahead. I don't know. Is it the software novelty or like software patent
a
related or?
software cannot be patented anyways in India, so it's only the
Yes.
copyrighted. It will come under copyright.
Yes, sir.
Because
In
Maybe,
as we are talking about software, as well, there is one
yeah.
more thing, sir. If you think that your software is commercially viable, and it can give you a very good amount of money if it is commercialized, what we can do, though it is not patentable in India, what we'll try to protect, we'll try to draft in such a way that at least it gets a reasonable attention of the examiner.
okay.
By filing in India, what we will also, that means we are the first one, you are the first one to file this idea. So that means an invention is filed on your name, though it is software. Forget about it will be granted or not. You have submitted the idea to Indian Patent Office.
Okay.
Then what happens? So you think that it is very commercially useful to some businesses in maybe US or Canada or Australia, where software patenting is possible.
Okay.
Then what we'll do, you can take the same equivalent invention. It's called as a family invention, family patent, or equivalent invention. You can file in respective country.
Okay.
So within 12 months. Within 12 months. So that means forget about Indian, whether it is granted or not. I suggest if it is commercially viable, so you file in India,
Okay.
and then you can on the, if you have any doubt, you can also file as a copyright on the same day, so that none of them are a prior art, because date is very important in IP.
Okay.
Prior art date. So that means file the patent application, file the copyright on the same day.
Okay.
So that means you can file the patent application, copyright application on the same day, and till 3rd of March, nothing was there. No patent application was filed, no copyright application was filed. And 4th, you file both.
Okay.
So both will be going in two different directions. You do not know which one will be granted,
Okay.
which one will be registered.
Did Suniji, did we, I mean,
Yeah,
are
I
we
got
able
that.
to?
Yeah, I got the answer, but I just want to know from Vijay Bhaskar sir or Srinivas sir,
Yes, sir.
at what stage the claims drafting come in place with the inventors?
So once the invention is complete, so main thing is, so the claims are nothing but the heart of any invention. Heart.
Okay.
Claims are heard. So claims are written in techno-legal languages, and sometimes it looks like repetitive, but they are not really repetitive. So it will be very boring for an inventor to look at the claims.
Okay.
It is very very important, because claims are those claims are those points which will be examined, even like examined at a minute level, including a and the comma, semicolon, full stops. So that
Yeah.
much detail will be taken by the patent examiner and the controller of patents.
Okay.
So
Mostly
they
they
will
are
be
from the
examining.
law background to look at the
No,
detail.
they are technical. They are technical people. In India, we have four groups,
Okay.
mainly like life sciences, yeah, mechanical, and electronics, and what is that one more, uh, chemistry.
Oh, okay.
Four groups. So they will have the relevant experience. They will have the relevant knowledge on the inventions. Like if you, so any invention, they'll try to give it into one of the groups, one of the four groups.
Okay.
So they will be looking into the claims, and they will be assessing whether it is really novel or not.
Yeah, they might be
Once they
knowing it
found,
based upon their past experience, they can easily figure out.
that is one thing, and definitely they will also conduct a patent search. How a patent search of independent practice conducts, they will also conduct.
Okay.
So they will also have access to various databases. I mean, not only one, the various databases,
Okay.
and they'll try to prepare a report. Nowadays, even they are giving the search report, how they have concluded their search and what are their findings, and
Okay.
they give those documents in the examination report in the form of various documents called as cited documents, in the form of D1, D2, D3, D4. Like means each document they will give one numbering called as a D1, D2, D3, and so on, so forth.
Okay.
D1 is very close to the invention. So that means sometimes it may happen that whatever we want to file is already there in D1.
Okay, sir.
Yeah.
So,
And maybe partly disclosed in D2 and is also disclosed in D3. So then in the examination report, he will give saying that whatever the invention is there, claim 1 to claim 10, are already disclosed in D1.
okay.
Then what happens? It is the duty of the applicant to provide differences, between the invention and the cited document. Please
Okay.
listen carefully.
Yes, sir.
It is the duty of the applicant. The examiner only gives questions. So as a student, we need to answer each and every point. So there will be around 15, 20 points in the examination report. We need to comply each and every one, each and every point,
Okay.
Otherwise, what happens? You may think that, okay, maybe I have answered most of the points, but only I did not answer only one.
Okay.
Still a patent will not be granted. Most likely, it will go for hearing.
Okay.
A hearing. So that means the reply submitted is unsatisfactory and not completely not complied with the objections raised. Then let's say there are about 20 objections raised and 19 are answered. Then the 1 point will goes in the hearing notice,
Okay.
saying that this objection is not complied. So you need to comply during the hearing part.
So behind every inventor is a patent agent, or probably anybody who is, probably it's a firm who is helping him get the patent grant.
Yes, yes, yes,
So,
definitely.
Sunichi, any other questions, or like I'm not sure if you are answering.
Yeah, just one more question.
Yeah, please
So
go
I
ahead, sir.
think Srinivas sir can answer this one because I don't know, because I'm very new to this particular subject. I'm still learning now.
Okay.
So maybe I'll be completing my law also this year, by
Oh,
June.
great.
Wow.
Yes.
So I was thinking to come into this particular field. So I don't know because I have a background of bachelor's in pharmacy as a pharma graduate.
Okay.
So I'm a graduate in pharma, but somehow if I start practicing, I don't know how the other inventors will think, because if there is a mechanical invention or some
Yes, sir.
other software invention or any circuit related things are coming up to me, so they I don't know, they don't know. I have my expertise only in pharma, but how they will understand as a patent attorney or a patent agent to draft the claims. So is that anything you faced in your experiences while
Yes, a
starting your career?
lot many problems. It's not so easy. It's not so
Yeah,
easy to understand
yeah,
any invention, even pharma or even because we
yeah,
think that okay, we'll be going in one direction, whereas the
yeah.
inventor he might be a master in other topics. He
Correct,
wants to,
correct.
and we need to match his pace.
Correct, because his way of thinking and thought process would be completely different, and we, as a technical and legal experts,
Not only that, he is
yeah,
hiring to understand and
yeah,
to go with him on his
correct,
pace.
correct, yeah,
So what we'll do, so we'll be spending a lot of time on that invention relating to that one. Okay, what exactly is happening? Uh, whether
yeah,
like in order to understand, maybe you read that research article, you need some prior art patents, you need his document again and again, again and again. That's
yeah.
what I do. And
Okay,
you prepare a questions. Okay, sir, here you told, but I
yeah,
read like this, and here I'm not able to understand how this substance is created, how this process is created, how this sub assembly is interacting with other components. Then
yeah,
he'll be very happy. So if you ask questions to inventors, right right questions, I mean, so anyone can ask questions, but after going through the invention, if you ask, they'll be
hmm,
very happy. Okay, this person has gone, and then he will give 200% explanation.
okay. So it's a mutual thing. We need to go hand in hand to draft the claims. Actually, it's not that easy,
Yes,
because even if I am a pharma graduate, but now the science has gone very far actually, because now into
you
molecular.
can. Yes, sir. What
Yeah.
you can
So
also do is you can
yeah.
also collaborate with other attorneys.
Okay. Okay. Yeah. Okay.
I guess the examiner, it depends upon how well the examiner and the inventor or the patentee gel with
Yeah.
each other's question and answers. If it's convincing enough, I guess I'm sure it's the least time is 1.5 year, right, sir? Vijay Bhaskar, sir. The
To
uh,
get a grant,
yeah, yes, sir.
no,
Yeah.
there are certain expedited routes. You can get it. Expedited routes, like filing of early request for early publication and filing for early request for early examination.
Okay, mainly women have that privilege, or
Yeah, startups.
okay. So, so let before we jump into Form 2, Form 3, and Form 18, and couple of other forms, sir,
Yes,
for
sir.
getting this filing of the patent within the applications. Before we get into the other forms in the application, Sunitji, any other questions, sir?
Right now, no. I think they can
Okay.
continue their
Yeah,
talk
yeah.
maybe.
Thank you. Thank you.
In between, if I have
Okay,
anything, we
okay.
can. Yeah, please continue, sir.
Yeah, thank you, sir. Thank you so much. So, Vijay Bhaskar, sir, so
Yes.
when it comes to Form 2 or Form 3, could we jump into the other forms which needs to be filled for filing this patent application?
Yes. So here I was telling
What
two
form?
parties are there in the patent application. One is inventor and the other is applicant.
Yes, sir.
The applicant is the one. The applicant is the one who has the rights on the invention,
Okay.
and the inventor is the one who is paid by the applicant.
Okay.
So he has to assign the rights. He has to assign the rights.
Okay.
Who the inventor has to assign the right to the applicant.
Okay. So,
Yeah.
yes, sir. I get that.
So here there is one Form 5 endorsement of inventors, and even on the Form 1 as well, the inventor will be signing, saying
Okay.
that, or even some companies follow like assignment, like,
Okay.
or the endorsement. Like they have a standard format where they say that so and so I'm so and so inventor, I am assigning this invention to the particular company.
Okay.
So once you assign, so that means you do not have any rights on the invention.
Okay.
So that means the ultimate rights will be with the applicant.
Okay.
So it is on the Form 5 that endorsement of inventors we call. That is
Okay.
one. And once the applicant gets rights through the endorsement of
So it's a declaration of the inventor.
yes.
The
Yeah.
Form 5.
So Form 5 and one Form 1 the inventor will sign, and the applicant gives rights to the agent in the form of Form 26.
Okay.
Authorization form it's called as.
Power of attorney.
Power of attorney,
Okay.
authorization form 26. Yeah.
Okay. So what about this Form 2, Form 3? Those are regular for the filing of this provisional specification.
Yeah, for filing provisional, we do not need any forms. So we
Oh,
have an invention, and uh,
okay, sir.
you for filing provisional, you do not need any forms. So only thing is whatever the information is there with that, you can file the invention in a couple of days.
So even if it's a foreign
So
application in India, is that possible, sir?
provisional generally for foreigners, how you are filing? If it is like, let us discuss about that later because it will be confusing to others.
Okay.
Like for Indian applicants, startups, like they think that they want to go to a conference or somewhere and they want to present it because they want to get some attraction or they want to get some attention or revenues, whatever you call.
Yeah.
So they want to disclose that idea. The ultimate purpose is they want to disclose that idea.
Yeah, they want to be an
And
authority in whatever the invention they are going to put it out in the market. They want to show their authority. Kind of influencer game, probably indirect marketing, we can say. Yes, sir. Please continue. Hello.
It's on mute, I think.
Yeah, Vijay Bhaskar, sir, you're on mute. Maybe sir might have received a call, sir. Could be one thing. Or else sometimes what happens is as this LinkedIn audio event, sometimes the browser keeps refreshing or gets exited out. Okay, sir, went back to. Okay. So Vijay Bhaskar, sir. Okay, there you go.
yeah, are you able to hear me?
Yes, sir. So you
Yes.
said if the patentee or probably the inventor wants to declare it to the public, that's where we stopped. We lost you there.
Yeah. So mainly, yeah, provisional patent is the one. So this which serves the purpose. So that means, so if you file a patent application today, and tomorrow you are going to a seminar, conference, or public place where you are disclosing idea,
Okay.
and you'll be talking about so many things about the invention.
Okay.
And what you have to do? So you have to find at least a day before. If you are going tomorrow, at least today, by today night, on today's date. I repeat, on today's date, file a provisional and then go to the seminar, conference, wherever the meeting you want.
Okay.
By doing so, when is your filing date? It is on 4th March. When you are
Okay.
disclosing on 5th March.
Okay. Today.
So this is the importance of the date, though within hours as well.
Okay.
So the provisional application will have a filing date.
Okay.
Though you are filing complete specification after 10 months or after 11 months within the period of 12 months. So what happens? So you are well within the time and your filing date is 4th March 2024, not the year end, not the within 12 months. So today's date will be the filing date.
Okay.
So that is one of the advantages of filing provisional.
Okay.
So here with the rough sketches. So patent drawings has to be provided only in 2D forms, 2D drawings,
Okay.
line diagrams. But even there are rough sketches, rough sketches are also
Consider.
allowed in the provisional.
Okay.
Because why? This will not be examined. But only thing is So if required, they will look into that one. So why? Because in the complete specification, the invention should not be completely different from the provisional.
Okay.
The invention should not be completely different. Rather, the invention should be developed on the provisional.
Okay. It should be an
So
extended version, and also for this
yes,
examination, also we have to fill a form, sir.
yes, that is the Form 18. You are talking, right? Form 18 and Form 18A. So Form 18 or 18A is for examination. So both are different. Form 18 is for normal examination.
Okay.
Form 18A is for expedited examination. What is the difference? The fee is the main difference. The fee is 4,000 rupees for normal examination, and it is double 8,000 rupees for expedited examination.
Okay.
Why I should go for expedited examination? Because it will be examined clearly. And why? What happens? So because if that means you are clearing the decks, right? Clearing all the obstacles.
Yes, sir.
So once you clear that one, then only a patent will be granted.
Okay.
So why I should get a granted patent? What happens if I have a publication? It is only the granted patent, granted patent that will give you the legal rights. Just mere filing, mere publication of application will not give you the legal rights.
Only.
What do you mean by legal rights? You can stop others from infringement only if your patent is granted.
Okay.
If your invention is granted in India and your invention is valid. So I repeat, valid. Valid means that you are. I said no renewal fee has to be maintained paid. Did I say? No, right?
No. We
Okay,
didn't talk about
okay, the renewal
it,
part.
but
Okay,
the
okay.
examination form 18. After
Yes.
that, again,
After filing the form 18 or 18A, we'll be getting one examination report.
safety
Here
check.
we talked about what has to be done in examination report, right?
Yes, sir.
Main thing is who can file the form 18 is also important.
Okay.
Form 18 anyone can file. Even any other interested party can also file. Why any other interested party? Why they have to file? If I am your competitor and you are the first one to file the invention, you are the first one. I agree, but I want to know whether it will be granted or not. If it is not granted, that means it becomes public knowledge.
Okay.
Anyone can enter it. If it is granted, then it is your. That means you have the whole and sole rights on the invention.
Okay.
So sometimes what I do is, as a competitor, I file request for it because you are not filing, and if you do not file, I do not know whether the patent will be granted or not. If it is granted, then I will be in trouble because I am going to launch my products.
Okay.
That is one way. And generally, the applicant he himself, 99.9 times, the applicant himself files because we have to see that the rights, the legal rights will accrue only after grant.
Okay.
In order to do that, we need to do this one.
What
And
about
even for startups, for investors, so the investor will ask, okay, this you will be saying that, okay, my invention is already filed as a patent, as one patent, two patents, three patents. Okay, fine. Ultimately, we'll ask, is how many of them are granted? You tell me. If you say none, then he will hesitate. Okay, now at least you show me the search report where someone might have conducted a search. Show me that it is positive.
Okay.
Even if you are not. So that means he will think that you are bluffing me only to get investment. You do not have any real invention.
Okay.
So yeah, so the examination report is one of the crucial steps.
Okay.
Yeah.
And what about in case if there is an opposition, sir, like before the grant?
Yes. So who will oppose? Who will be aggrieved? Who thinks that he will be aggrieved because of this patent if it is granted? Why? What happens if a patent is granted? So that means no one can commercialize that product, process, method, composition, the subject matter of patent.
Okay.
No one can commercialize without the permission of the applicant.
Okay. So again,
So as a competitor, what will I do? So I'll try to oppose because if some way or the other it is related because everyone wants to get a market share, right?
yes, sir.
Maybe you are the first one to file a patent. It doesn't mean that okay, what he will sell. No. This subject matter was already disclosed in a US conference or somewhere in the net or somewhere in the blog or somewhere.
The best
So what
example
we'll
is
try to
the recent vaccine for during the pandemic. There are lots of vaccines, right?
yes.
We are yet to bring that report, but those can be the best examples. Somebody else has.
No, even many companies, if you look at so many pre-grant oppositions, post-grant oppositions.
Could you
So
give,
that means only once you are into commercialization, then we'll understand this one.
can you
Why
give
will
some
anyone will
examples,
file?
sir, for a normal? I mean, somebody who is newbie like me. I don't know what kind. Any famous oppositions?
Like
Thank you. Thank you, Charita.
a bit confidential, but I'll say in a general
Okay.
sense that let's say you are manufacturing some soaps or shampoos or anything, right?
Yes, sir.
So you have come up with a new composition for a shampoo,
Okay.
and you have filed a patent application.
Okay.
And because of this, what happens is like there is so much of craze in the market,
Okay.
and every time in the ad you are saying that it is a patent pending.
Okay.
You are creating some fear in the competitors.
Okay.
As a competitor, what will I do? I go to a law firm or a IP attorney saying that, sir, so this person has not done anything, but he has filed a patent application, he is advertising, he is putting patent application number, and he is almost giving indirect way through all the competitors. What should you do? Then,
Yeah.
as an attorney, I said, be quiet, don't worry, let me do something. Then, what I will do, I look into that patent application and find that he has done only the form change, maybe a little bit of the same thing was already there in let's say traditional knowledge. Maybe in some community, people were already using that one for years,
Okay.
but it was not patented anywhere. It was not published, but
Okay.
it is already a practice, and you have got some information in a local language that it is already in use.
Okay.
Then I'll go to this competitor and say, no, yeah, what you said is correct. He has not done any invention. I've already got a solid proof. So right now it's only published. So it did not go for examination, or right now, even if it is gone, it is not yet granted. So what we'll do, we'll file a pre-grant opposition.
Okay.
So what happens? The examiner or the controller, the patent office is bound to take this objection. So
Okay.
without taking this into consideration, they cannot grant the patent.
Okay.
So
So
in the
you,
business, it is an asset to a competitor.
okay. Even the
Yeah,
exam.
by this, sir, I remember like Huawei last year has filed around 7,000 patents applications. I don't know how many of them
Yes,
will be granted. So they want to create a fear in the competitors, might be.
yes, that is very
That is
common
the
because even
strategy.
I
Yeah,
worked in a mechanical engineering company. So sometimes
yeah,
it is not only to protect. So if you look at the companies, they'll think from 360-degree angle.
yeah,
You never imagine why they have filed.
yeah.
So the purposes could be very interesting.
I think the same
What
thing in
happens
5G
is like
technology also. Like there are lots of examples in
anywhere.
5G.
So what happens is as a company, so what will I do? If I do not get, no one should get it. That will be. If I do
Yeah,
not get, why no one should get it? If someone gets, again he will object me.
Yeah,
Yeah.
commercialization of
Then what will I do? Though I know that it will not be granted, I will give very good examples and other things, and I'll try to be the first one to create that application before someone else,
okay.
and I'll try to get it published. I'll try to get examined, and even if it is refused, also fine, because that becomes a public knowledge.
Okay.
Yeah. So that is one purpose,
So
and the
yeah,
other
because,
is to
yeah,
increase
correct.
my company valuation.
Yeah,
Yeah, to
okay.
increase, how
yeah,
can it affect? You say this is IP oriented, we have 200 researchers, we have filed maybe 2000 patents before Indian patent office. Then the investor will think, oh yeah, such a great company, 2000 patents,
correct.
200 researchers working on invention, so maybe nothing wrong even if I spend $1 billion for this company.
So if we take the case of Huawei, they are filing around 19 patents every day. If you take 7,000 odd patents are filed every year actually. So they want to create that. Maybe what you said is right. The investors will be interested and keep on funding, and they do a lot of research. That's what they do.
Yes, and also create a fear in the competitor. Yeah. Why, when you can do business if there is no one outside, right? Again, because if there is no someone, again, you need threaten him, even legally. Like, so you are filing and there's some, even if he's doing a genuine product, he may think, hey, yeah, this should may file some cases, legal cases, and again, it will be difficult for me because the legal cases, as you know, are pretty costly. Yeah, because judgment is adverse to you. Correct. You need to pay a lot of amount in the form of penalties. Yeah, if they infringe. Yes. So there will always be a, so like that, if you are a big company, you know, money is not a problem for you. What you are spending on patents, money is not a problem for you, for big companies. So that's how. So here we need to see that one. So what is the purpose? Only the management team will come to know why they are filing. No one else. But as a normal person, we think that they are doing great research. This that no,
Yeah.
the idea behind that filing will be different for every patent application. They know that one for what purpose they are doing. Is it for commercialization of their own product? Is it to make the knowledge of that invention as a public? Is it to get some kind of attention from someone else? Is it to get a partnership with some universities or with someone else? Or is it get to noticed on this technology? So
Okay.
different purposes will be there.
Sir, I have a question regarding the pre-grant opposition in India, Indian Patent
Pre-grant.
Office. Yeah. So this Form 7A I'm talking about. So when do the controller accepts that pre-grant opposition? After we file the examination thing
After
or
we file
before
during
that?
the no no during the examination normally
Yeah.
during the examination, even though if it is published. So how do you come to know? Once the patent application of the opponent is published, you will come to know that the opponent has filed a patent application on
So
particular
that means you're
technology.
saying after 18 months that only the provisional
Why
will be
only 18
published.
months? No, no, no. Provision will never be published as such. Only the
Yeah.
complete specification.
So
Once you
that's
file
what.
the complete
Yeah. Okay.
specification, so
Okay.
what happens? You might have filed Form 9. So that means your date of filing the complete specification is 4th March, and you might
Yeah.
have filed a Form 9 as well. So
Correct.
within 1 to 2 weeks, it gets published on every
Okay.
Friday. On every Friday,
Yeah.
the patent office publishes respective patent application for that particular week.
S-
So,
So the controller will only consider that pre-grant opposition after we file for an examination. That's what you're saying, sir. I'm right or
During the
do?
examination,
Okay.
during the
Okay.
examination,
Okay.
because
Okay.
he will not look on a daily basis, no,
Okay.
no
Okay.
use. So
Okay.
he will wait it. He will wait, or you might have filed a pre-grant opposition after the examination is over. Before grant, he will look at it. Before grant
Okay.
as well, he will have a look at whether
Okay.
any pre-grant opposition is filed or not. If
Okay.
it is nothing, is there no objections? And even other thing is, as you are from pharma background,
Yeah.
before grant, what he will also do is he'll also see whether that NBA approval is obtained or not. National Biodiversity Authority for
Oh,
inventions relating to mainly plant related plant related inventions, like if method like if you are using any shampoo which is extracted from particular plants, yeah,
okay. Okay.
then in that case we need to get approval from the National Biodiversity Authority.
okay.
Okay.
So, thank you so much for all these insights, sir. Before I go jump into post grant opposition, just want to thank Charito Yamar. Charito, thank you so much for listening to this live. If you like to speak or join, or if you have any questions, please join the speakers panel by raising your hand. Thank you, Chandrasekhar, Satish, and Lakshmi, Harisai for tuning in live, listening to this conversation. Yeah. So after the grant or post grant also.
It's possible up to 1 year.
Oh,
Post grant
okay.
is also possible up to 1 year before the patent office.
Before 12 months. Yeah.
Yes. And thereafter, what you can do, you can file revocation of a patent in high courts.
Okay.
Still possible. So
Sir,
at
are
any
there
time,
any
yes.
specific IP codes in Hyderabad, sir, as like Delhi and Chennai?
I do not see any IP because only it is the high court. Any high court will accept.
Okay, but like Delhi has already set up some exclusive IP code
Yes,
as
yes.
well as in Chennai as well. So I was thinking
No,
anything will come up in the future
no.
in
Yes,
Hyderabad.
yes, yes. Depending on the number of cases, no. If High
Oh,
Court thinks that it is a burden for it, it will develop a branch under it, saying
okay.
for like right now at district court, what we have is commercial courts, right? Every district court has also a commercial court
Yeah, because the appellate
relating to
has board
business.
has been dissolved,
IPAB has
so
been dissolved.
so maybe
IPAB, I
the
think
case load might come to the High Court. In that case, then if there is a load, then you're saying that might be coming up
it might
exclusive
come
courts.
because it might come. It
Okay.
definitely, but only time. So whether it
Yeah.
comes after 2 years or 3 years or 4 years, that we cannot tell, but it will
Okay.
come
Okay. 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 Please continue,
because
sir.
yeah.
Yeah, and we have
So this post
Charito who
grant,
wants to
yeah,
join, sir. I'm so sorry to interrupt you there.
yeah.
Srinivas, sir, could you please approve Charito to be in the speakers panel? She raised her hand. Uh, okay, I'll just reach out. Okay, there you go. Yeah,
Yes, I just approved. Sorry, actually,
that's okay. That's okay, sir.
I
That's
should
okay.
have actually passed the controls to you.
That's okay, sir.
My actually my hearing got extended, so that like I'm unable to take the session. Sunit Garu, sorry, I should have joined this, but
Okay.
I think like Vijay sir is all guns.
Yes, sir. I think most of
Yeah.
the questions has been answered by Vijay sir, so
Yes.
I was
Yes.
convinced
Yes.
with all those answers.
inventing almost everything, right? So in
Yes,
that case, yeah, because if that is not that you have a division or a government arm which controls this patent, right, sirs? So
yes,
in that, but then maybe I can see your criteria is not so strict because of that, or it's too slow in accepting or approving all these patents around, because they're wasted away if they it takes a year 2 years for them to be approve the patents there. Do you get my point here, sir?
yes,
Is my question clear?
yes, yes, yes. So
Just
earlier,
curious.
yeah, earlier the process was very slow in India. Right now, the Indian Patent Office is equipped with enough personnel, enough examiners, enough controllers. Yeah, and now it is so fast. If you look at the year-end report, maybe for the past 2 to 3 years, so you can see the drastic number in filings increase, the drastic increase in filings, as well as the drastic increase in disposals. Disposals is one, right?
Uh-huh.
So they are getting examined very fastly. They are getting granted very fastly. So it was no, it is not the case earlier. So right now, even the numbers have gone up. The number of filings have also gone up in the past 2 to 3 years.
and
So I suggest to get any conclusion. I suggest to take only 2 years data.
okay,
Hmm.
okay. So that's great,
That's
sir.
it.
Again, I'm sure with the advancement of technology and tools, things are faster now with the personal.
Yeah.
Thank you, Charito, for that.
Did I answer, Charito?
Yes, very much. Just one last question. It may
Yes, please.
seem out of place. What do you think, in your experience in the government in India, are those not accepted, or those accepted patents, when they go into the marketing world, into the market, do you have an arm there to check whether, like, were you right
Infringement.
in accepting them? Like, the patent was approved and it was thrown into the market for everybody to use, and then it was not selling well. It's just like, you're wasting your time. Even if it was approved, you get what I mean? Not
Yes.
everything is perfect, right, in this world.
So
So even if
here,
yeah.
here what we have to see is any patent is likely to be a
Yes.
commercial asset, right?
Yes, sir.
Yeah, any patent in any country.
Oh, yeah.
But yeah, in any country, why we are filing in order to get a patent rights, in order to get exclusive rights, right? In order to get
Yes, sir.
exclusive rights, so that only you can manufacture, you can sell it, you can license it, right?
Yes, sir.
Yeah,
Okay.
yeah. So
So,
even in India, so what happens is earlier, because it is not. If you look at some maybe past 5 year data or 10 year data, so maybe the number of inventions that are commercialized, maybe some 5, 10 years back, are very less. The number of filing itself are very less. But as we, if you take some 2 years data or maybe last 1 year data, so I've been seeing so many inventions are commercialized.
Okay.
I need to say, sir, that the government is only up to, I mean, the stops back there, only up to approving, and after that, it's the applicant himself
Yes,
is, yeah,
yes.
role responsibility if it really works or not. So that's it. Thank you, everybody. I was just curious. Thank
Yeah,
you
yeah.
for
Thank you,
giving me
Child.
the room. Okay.
Yeah,
Okay.
maybe I have answered your question. So
Yes,
here
very
what
much.
happens, yeah, here what happens is like every applicant should think, and it is the intention of getting any patent granted is to commercialize and to get revenues out of it.
Okay.
But here, what happens is like in India, again, we have one Form 27, which has to be filed by the applicant every year regarding the commercialization of that particular patent, whether it is commercialized or not, yes or no.
It's like working of the
If yes,
patent.
yes, Form 27.
Yeah.
So if it is worked or not, working means nothing but the commercialization.
But Vijay sir, it is up to the inventor or the company to create a value of that particular patent and exploit
No,
that
here
patent in a
here
commercial
we have to
basis.
see in a broader way
Yeah.
why the government is giving you the rights. The ultimate purpose of any patenting system is to increase the standard of living of the people. To
Okay.
increase the standard. How? So once that period is over for that particular invention, it becomes a public knowledge. Anyone can use it. It could be a
Okay.
pharmaceutical invention, it could be electronics invention, it
Correct.
could be a mechanical invention. No need to take permission. Any manufacturer can manufacture and sell. So in that way, he's getting knowledge through in terms of by reading patents. Yeah. So he's able to launch a new product.
Okay.
So this is why the patent office, the government gives right. And the government is expecting only the applicant should do that one. But if he's not doing, and if he's not paying the renewal fee for that one, so the patent is abandoned.
Okay.
Once the patent is abandoned, anyone can. So within we will wait for 18 months. 18 months is the maximum time for restoration of lapsed patent.
Okay.
So once that 18 months period is over, it becomes public knowledge.
Okay. And what
So
is
anyone
this
can manufacture. Tell me.
biological material deposit, sir? Again, this is with respect to only. Uh,
Yes, it's only related to biological materials. So that means in order to have a proof that you are creator of so and so and so and so date, so you need to deposit the material before the, mainly it is in Chandigarh, we have an institute,
okay.
biological deposit. So we are there, you need to deposit and they take care of in the standard way to, in order to protect that biological material, because tomorrow you may need that one, the sample, and it is very important in life sciences to know about that one, whether it is what in order to about DNA or any other thing. So it has that species or that sample should be live. So for this you do not know what you are claiming.
Okay.
So if there is anything, then they will refer to that one, biological material, and they will ask to do the respective relook into that one.
Okay.
It's only for life sciences mainly.
Okay. And that would
Not
be.
only in any country, in every, almost in all countries, it will be there.
Okay. So, again, great insight, sir. Suniji, do you have any other questions, sir, before we wrap it up for the day? I should thank all the listeners, Harisai, Lakshmi, Satish, Chandrasekhar. We also have Sakuram Gugulat, one of the scientists from Bureau of Indian Standards. Feel
Oh,
free
nice,
to.
Saguram, sir.
Yeah,
So
I don't have anything right now, but I think you can cast some more in the future. This sort of short,
sure,
what do you call the
maybe
gathering? Yeah,
yeah. As a listeners, you can post. Mr. Raj will collect and he will put it.
yeah,
Maybe
yeah.
sometime later, means Mr. Srinivas or I will address them.
Sir,
So
if you want to meet you in person, where is your office located in Hyderabad, sir?
so you can come to Eva office. We can meet there.
Again,
Acha.
We're at Bharat Nagar, sir.
you can
Okay, Bharat.
you can just go to eevatech.com, sir. Under contact us, you
Okay,
can navigate. We are at the metro station, just like 100 meters away from the metro station.
Bharat Nagar metro station.
okay.
Uh,
It is towards LB Nagar. Where is Bharat
No,
Nagar?
near to Kukatpalli.
Acha, Kukatpalli, Bharat Nagar. Okay, okay,
on the way to.
okay.
But again,
Sir, any office mobile number so that we can just contact before coming
yeah,
if you are there in office or somewhere you're out of station, we don't know. So just any mobile number or
Yes,
any
yes. You can
landline
just
number.
email us. Yes, it is
We
there.
have an appointment form, sir, on website, or otherwise, like I'll text you.
or if you click
So both the numbers.
If you click Srinivas sir's profile, we have one
Okay,
mobile number listed there.
okay,
We'll
okay,
also put, even if you go to
okay,
Eevatech
okay.
LinkedIn page, you'll find all the numbers.
Yeah, only because we come from a long distance, so in Hyderabad itself, but it is taking 2 hours to reach
No, no,
any
no.
place now.
No. Even it is
Yeah,
nice
yeah, yeah,
practice to take any
yeah,
appointment from anyone because
yeah,
you.
yes, sir.
Yes, yes.
I'd like to
Yeah.
thank Venkata Sudhir Goligaru, one of our partners, senior most partner in EVA. Thank you so much, sir. Sudhir.
And I want to listen from Sakuram sir because he's from BIS. Maybe if you can
Yeah.
throw light on anything, it
Yeah,
will be useful for each of us.
Sakuram
Sir,
sir,
Sakuram sir,
if you could raise your hand, I'll allow you to be on the speakers panel. You just need to use that react button. Even Sudhir sir.
Sir is our old acquaintance actually. So he's a great person. Sir, can you please raise your hand
Yeah,
if you are free?
I mean, this LinkedIn is tricky for newbies.
Yeah, it was difficult for me also to understand. So this is the first time I'm using this one. So
Next to react button, there is
yeah, yeah.
raise hand. Oh, there you
Raise hand, yeah.
go. Okay, there you go, sir. Sudhir garu, you can also join the speakers panel.
Sir, how are you, sir?
Yeah, fine. Srinivas garu, this is nice. I have just looking that you are on online, so I thought of joining your.
Yes.
Great, sir. You are in Telangana, Andhra Pradesh. Where are you, sir? Presently posted.
No, presently posted in Delhi,
Great, sir. Great, sir.
headquarters.
But chief scientist
Oh,
all the
great.
way from Jamshedpur to all the way from Delhi again connecting. It's an honor talking to you, sir, as a chief scientist at Bureau of Indian Standards. Yeah, I'll leave it to Vijay Bhaskar sir and Srinivas sir or Sunit ji to pour in more questions for Sakuram sir.
sir,
Yes, sir.
we like to
Your
hear from
current
you,
profile,
sir.
sir.
Hello.
Yes, sir.
Yeah,
Your current. Yes,
I am.
please go ahead, sir.
Yeah, presently posted in enforcement department in BAS, New Delhi.
Super. Yeah.
So it is headquarters. So all over India, I am looking after that.
Great,
But
sir.
lot of so many new products and new quality control orders are coming. So
Yes,
it
sir.
is interesting also to see that this is a very interesting topic and required for now present generation. Yeah,
Yes.
lot of intellectual property rights are lacking because of lack of knowledge and how to go the process. So I know Srinivas is doing since he is bringing so many things to other people, and I wish him all the best in future also because like uh, how to get registered is very difficult for so many people. So it is
Yes,
one
sir.
of the best platform to people in India to acquire the right.
Yeah, that is totally right.
Thank you very much, sir.
Yeah, Sakram sir, whatever you said is very true. In fact, we wanted leaders like you who has been there for decades to help us
Yeah,
create more awareness or to share these knowledge sessions.
yeah,
Again, I love your about on LinkedIn, which is I wanted others to examine. But again, this is good, sir. You are like an ocean of wealth, of knowledge. But again, your
yeah,
LinkedIn about says nothing special, but you are a chief scientist. You have seen many youngsters out there who had shared their
yeah,
various inventions, or probably with respect to inventions. So, Vijay Bhaskar,
yeah,
sir,
yeah.
you have any questions for Sakuram, sir?
But queries,
Uh,
so, so many queries receive. I will refer also. Okay.
Okay,
okay.
sure, sir. Sure.
Sure, sir.
Uh,
Yeah. So I think even we
yeah,
are, I think, running out of time as well. Yeah.
Okay,
So I think
but
we can.
Sakram sir is here in Hyderabad for BIS 10 years back.
oh,
So I know him. Then we lost in touch, but thanks to Raj actually, and as well thanks to LinkedIn Live.
thank you for joining us
yeah,
live, sir. We will
thank
again connect with all the listeners tomorrow, as Vijay Bhaskar, sir, has reminded us about the time. We just ran out
Yeah.
of 10 minutes extra, but thank you,
Okay.
Charito. And all the listeners, we will see you live again tomorrow with Srinivas, sir, tomorrow at 5 p.m. Thank you, Sunit ji.
Thank you so
Sakram
much.
sir, actually will have a session exclusively with you, sir, with the developments BIS PCI in combination and about your present role as well to our listeners, mainly into trademarks. So we
you.
will plan one, sir.
Yes, yes, yes. Sure, sure.
Sure,
Okay,
sir. Thank you.
that's
Okay,
great.
thank you.
Yeah. Thank you. Thank you all.
Yeah, Vijay
Bye.
Yeah, thank you,
Bhaskar, sir.
Vijay
Thank you,
Bhaskar,
sir.
sir.
Bye bye,
Thank
sir.
you.
Take care. Bye, all.
Thank you, Sakram sir. Thank you, Sunit Garu. Yeah, thank you everyone, Charito and Sai, Hari, Satish, all the listeners. Thank you very much. Good evening.
Thank you.
Yeah,
Good
have
evening.
a
Bye.
great evening, sir. Bye bye. Thank you, Sai Teja.